Good morning, everyone, and thank you for tuning in to today's Practical Strategies webinar about uncharted waters, navigating the GOS-E, the Glasgow Outcome Scale Extended. My name is Carr. I'm a partner with Thomson Rogers, and I will be chairing today's webinar. The webinar is being hosted by the Personal Injury Alliance. Those include the firms of McLeish Orlando, Oatley Vigmond, and Thomson Rogers. Before we begin, I have a few housekeeping matters to discuss. I'd like to remind everyone that the PIA Back to School Conference is coming up on September 20th at the Ritz-Carlton in Toronto. Early bird registration is now open and available until July 31st. For more information, please visit our website, pialaw.ca. You'll see on your screens on the bottom part there's a significant question segment today. It'll be the last part of our seminar. And to submit a question for our panel, just type in the question in the box at the bottom, just below the player screen. And we'll do our best to answer your question. If we don't get to it, we will answer it by email. So rest assured it will be answered. And if in case you can't stay for the full webinar, it will be up on our website shortly. And it's the PIA Law website. I'd like to introduce our panel today. We have a very experienced panel here who have many LAT decisions behind them. To my far left is Kevin Henderson. Kevin is a partner at Oatley Vigmond. To my left is Bani Ahuja. Bani is an occupational therapist at Omega Medical. To my immediate right is Colleen MacDonald, and Colleen is an accident benefits specialist at Oatley Vigmond. And to my far right is Lindsay Charles, who is a lawyer at McLeish Orlando. So today's webinar is about the LAT. We're going to focus on the catastrophic part of the LAT, and importantly, the GOS-E, the Glasgow Outcome Scale Extended. There is yet to be a LAT decision going through the Glasgow Outcome Scale Extended. We expect that to happen quite soon. The LAT, with respect to statutory accident benefits cases, is very much in its infancy, but we have seen some growth in the last 2 years, particularly in the last year, when some decisions have come through, including some CAT decisions. But to my knowledge, we've yet to see one that has gone through the GOS-E. Importantly, there was a case that came out last week called Shuttleworth, where it's been making the rounds amongst the personal injury bar and the treatment provider bar. And the issue with that case was it was a determination of catastrophic, and ultimately the decision said that the applicant was not catastrophic. But then the lawyer, months later, received a letter from somebody, an anonymous letter. And that letter said that the process may have been where the superior within the LAT went over the head or may have interfered with the initial decision, changing the applicant from CAT to non-CAT. And that's a significant issue, and the Ontario Divisional Court overturned that decision. They didn't make any finding that anything was wrongful, but they said there was an appearance of unfairness. So anyone that hasn't read that case, they should have a look at it. It's just an interesting read. But I spoke with the panel about this, and it seems to be very much a standalone decision, but it does show that the LAT is in its infancy when dealing with this area of law. That said, the decisions in this area of law within the latter, they appear, in my view, to be well-reasoned decisions. The adjudicators know what they're doing. We have faith in that. There is a delay in getting these decisions. It's taking a little bit longer than everyone thought, and they're starting to experience a bit of a backlog. But the good thing about the LAT so far is that it is moving things along to some degree. And of course, the main criticism of it from lawyers and injured people is that the cost consequences are leading to access to justice issues. Some people aren't bringing their cases forward because of the costs associated with doing that. And when you're up against insurance companies, that can be a problem with respect to access to justice. So I'll now give it to Bani here and Colleen. A bit about Bani. Bani's an occupational therapist from McMaster. She has a Master's of Science in Occupational Therapy. She's worked in the motor vehicle sector since graduation and has experience in pediatric and cognitive disabilities. She has worked internationally as an OT as well as being involved academically in teaching the OT assistant programs and mentoring at the University of Toronto OT program. She's participated in the CAD assessment training course for the AMA guides to the evaluation of permanent impairment. Colleen is an accident benefit specialist with Oatley Vigmond. She provides assistance to clients accessing the SABS. She has a number of years' experience working as an analyst in the major claims unit for a large casualty insurer in the area of SABS. Colleen is able to provide insight into the adjuster's approach to assessing files that have the potential for a CAT impairment designation and what makes a strong application for determination of CAT impairment. So Bani, we'll start with you.
Thanks, Carr. So I think I'll just start off by actually talking about the GOS-E assessment on its own. GOS-E is actually an outcome assessor of anybody who has sustained a head injury. And if you've seen the GOS-E structured form, it actually involves 5 basic domains. So we're looking at independence inside the home, outside the home, work, social and leisure activities, as well as the impact of head injury on family and friendships. The GOS-E application goes in at 6 months and 12 months. So when you do a 6-month GOS-E application, your chief focus is to look at the first 2 domains. So we're looking at independence inside the home and outside the home. And when you look at a 12-month assessment, the focus then comes to the remaining 3 domains, which is work, social and leisure activities, as well as family and friendships. So for a person to be catastrophically impaired at 6-month mark, they need to be severely disabled in the grading scale of the GOS-E at 6 months, and whether it is upper or lower, and then at 12 months they need to at least be lower moderately disabled. So when you're looking at the scale or the interview form itself, I like to see, when I get a referral for a GOS-E, I look at their medical file and see what has been documented since day one. And if there is a collateral, if I'm able to get a collateral of a family, friends, neighbors, anybody who can provide input in terms of how things have changed in comparison to before the accident for the client. So what we're really looking at is, when you look at independence inside the home, it's not just about, is the client able to make a meal and get through the day and be safe. We're also looking at, do they need prompting or cueing? Do they have a personal support worker at home? Is their spouse reminding them to take their medications? Are they able to respond to a minor domestic crisis, such as maybe their fridge broke down 2 days ago and they don't know what food to throw out and if it's safe to be consumed. Maybe there's a fire in their apartment building and they don't know how to exit it safely. Or even just somebody calling and telling them they won a free cruise. Are they able to identify what is real and how to keep their own privacy and safety at all times? So when the first domain talks about, are they able to stay independently inside the home for 24 hours, you have to look at not just their ability to physically exit their home in the presence of an emergency. You're looking at all the other aspects that make you safe in terms of your awareness and cognition as well. And then when you look at independence outside the home, you're looking at their ability to travel independently as well as shop without assistance in queuing. So they should be able to plan what they're shopping for and also look at handling money appropriately. And then if they're driving, that's fine. If they're not driving, then they should at least be able to call a taxi for themselves and direct the driver. When you look at these aspects, I think what makes a good assessment is your understanding of the symptomatology that comes with a brain injury. So there has been talk about how there is a physical focus on the GOS-E, but you have to look at when a brain injury occurs, there are physical, cognitive, and emotional symptoms that come from it. So physical symptoms such as dizziness or light sensitivity or fatigue, cognitive symptoms like impaired ability to recall information, plan, sequence, prioritize, make a decision, and then emotional issues such as impulsivity, disinhibition. You're looking at emotional lability, anxiety, depression. So all of those, if you have a solid understanding of the ABI symptomatology and relates that to the person's domains, then that makes a more solid assessment. When you move on to the remaining 3 domains at the 12-month mark, you are, not to say that you won't be assessing it at the 6-month mark as well, but it pays more to look at those 3 domains because you're really looking at the vast impact of the injury at that point because the client is 1 year post-injury at that point. So you're looking at whether they have been able to return to work 12 months in. If they have returned to work, do they need accommodations? Do they need help? Or have they simplified their life otherwise? So many of us have clients that they have returned to work, but that's all they can do. Their relationships suffer, their social leisure activities suffer, they're not doing much inside the house anymore, or they're not going out because they're just solely focusing on going to work and earning some money. So you're going to look at how the ABI has impacted their ability to work if they are. And then you move on to social and leisure activities, so whether they're volunteering, doing playing soccer, or doing community activities, and if that has been reduced, not only just because of the physical impact of the injury, but also due to the cognitive and emotional factors. And then family and friendship strain, we look at that as well. The article from Wilson in 1998 that sort of did a validity study on the GOS-E looked at that there should be a daily and intolerable strain on the family and friendships. And that piece, for that piece, it's really important for us to get good collateral and good documentation to be able to comment on it. I find that the stronger your narrative is, the stronger your assessment becomes. So I don't know, Colleen, if you need to add anything to that in terms of what I have said and in terms of what makes a stronger application for the GOS.
Well, certainly you need to align yourself with people who can assess the function. And I think having the collateral, will say statements, collateral evidence, records from rehab support, notes from rehab support
Yes.
workers of observations is really, really important.
Yeah,
For
and
sure.
I would just like to add to that. So when you think about treating OTs, if you receive a referral for a client who has a head injury, you're looking at from day one, you're looking at all these 5 domains. You keep that in mind, and you sort of build their file on that. Whether there are any instances of family strain, or if they've left the tap running several times, the family's informed that to you, or in front of you, you're practicing meal preparation, and they forget to turn the stove off. These are things you should be documenting in order to prepare for this application.
When ideally would you like to see the referral made to your facility for the assessment?
I think lawyers and clients can start thinking about this assessment right from the get-go, because if you have a head injury, there are great significant chances that you will have difficulty under these domains. It's very holistic. All of us go through these phases. We all have these distinctions in our life. So some or the other part will be impacted by the brain injury. So I think right from day one, you can start considering it.
All right, well, I guess it's my turn to go. It's great to be part of the panel today. Most of my career has been as an adjuster with an insurance company, and more recently as a claims analyst in a major claims unit for a large casualty insurer. The company I worked for was structured so that the bulk of accident benefit claims were handled in a larger unit, and claims that had a CAT impairment exposure were referred to a major claims unit. That being said, there was always like an ongoing process in that general area where files were reviewed for CAT impairment exposure, and that was done through communication with analysts and supervisors and presentation at a CAT risk committee, where a determination was made to refer it to the major claims unit or provide further instructions to the adjuster. When an application for determination of catastrophic impairment was received, we would have it wasn't a decision that was between the adjuster and his or her supervisor. It was the subject of a committee decision and determination. And that involved presentation of the file, the dynamics of the accident, the documentation that we had, GAF ratings, Glasgow Coma Scale ratings, imaging, and then a determination would be made to accept or reject. And if we were rejecting or denying the application, there would be a decision as to the vendor that would complete the insurer examination, the type of assessments that would be involved, and what, if any, documentation was outstanding that would be required for the assessment. It's really, really important to communicate from day one with the adjuster if you're on the law firm side of it. I mean, I think if you know that an application is for catastrophic impairment is coming in, you need to let the adjuster know. They can start preparing from day one, and it seems clear from what Bani's saying that from the law firm side of things, you've got to start looking at it right away as well. Get your file in order. Get the documents that you know the adjuster is going to need, and that'll include, obviously your clinical notes and records, pre and post accident, imaging, as well as the actual CD of the images, because they are going to be most likely reviewed by a neuroradiologist or a health practitioner to determine the intracranial pathology. Communication is so important. When I was mentoring staff in my previous role, I was always encouraging them to pick up the phone, call the occupational therapist, call the law office so you have a good understanding of what you're up against and you can plan. In terms from the lawyer's side of things, the law firm side of things, again, as Bani said, you need to start working at getting that collateral evidence, getting a rehab support worker involved to document what's happening in the home, will say statements, and aligning yourself with a therapist or providers who understand the criteria and who can assess function adequately. The other issue that seems to be coming up is the insurance companies use vendors to complete their assessments. And these vendors are having difficulty providing their assessments in a timely basis. And that's huge under the GOS-E at 6 months and 1 year. It's not good enough that the insurer examination take place on a GOS-E at 6 months, taking place at 8 or 9 months. You're not capturing the function at 6 months. So as in my position as an accident benefit specialist or at other law firms, I think we need to be creative in how we get these assessments done as close as we can to the 6 month and the year levels. And that may involve insisting that the assessment move forward, and if documents are required, reports are held or addendums are done. It may require that an insured person may have to travel a bit further for that assessment, or it may involve contacting the adjuster and looking at other vendors that are on their preferred list who may be able to complete these assessments and get them done in a more timely basis, or even going off the preferred list. But that's going to require the person at the law firm making those calls and making that case. And, you know, it may actually involve, you may have to move beyond the adjuster to get that done. I think at the end of the day, it's really important that we're communicating, we're working towards getting the GOSE assessment in from as soon as we can, getting the right people on the file, and being creative to deal with some of the challenges that we have under this new system and getting IEs done within a timely manner. And of course, aligning yourself with assessors who can assess the function. Thank you.
Okay, thanks, Colleen. Thank you, Bani, as well. So we'll move on now to Kevin. Kevin Henderson. Kevin's a partner at Oatley Vigmond. He leads a team of lawyers and support staff, and he aggressively pursues spinal cord, brain injury, and serious orthopedic cases. Kevin will provide an insight on an insurer's obligation when responding to an application. Kevin.
Thanks, Carr. So my topic is insurer's obligation when responding to an application. The issues I'm going to talk about are more dealing with how plaintiffs and claimants can use the obligations on the insurer to their advantage, specifically in a GOS-E claim. So, as we all know, the insurer has 10 days from receiving a catastrophic application to advise whether or not they accept the determination or whether they want to send it to an insurer exam. And then they have 10 days from when they receive the report to actually having to produce it. What they don't have is a specific timeline for when those assessments have to take place. And in the 6-month GOS-E specifically, there are some advantages there that plaintiffs and claimants can take advantage of to really have the GOS-E assessed on their terms and on their testing. So the first real advantage is with respect to the neuropsychological testing. So certainly as plaintiff's counsel or someone representing a claimant, you have the opportunity to select your assessor and select the environment in which they complete the neuropsychological testing. They'll complete that testing at 6 months. And after that, there's a fairly significant period of time where neuropsychological testing cannot be repeated because there's certain testing biases that become ingrained and the test ultimately becomes easier, leading to potentially invalid results. So in the case of a GOS-E application, you have the insurer neuropsychologist having to rely on the testing that was done by the plaintiffs. Otherwise, they risk having an invalid test, which ultimately, if a matter proceeds to the license appeal tribunal, will be ample space for cross-examination and fodder to suggest that their testing is somehow biased and will ultimately result in showing no impairment when there is one. Secondly, particularly in the case of rural clients, an insurer may not wish to pay to have their occupational therapist travel to the home to do an in-home or functional assessment. So the advantage of having completed an in-home assessment by the claimant prior to the application being made is that that assessment actually takes place in the home and it takes place at 6 months. So rather than sending someone who's perhaps in Sudbury or in a rural area to somewhere like Toronto to a more clinical setting, it's actually assessing their real function in their home. And this certainly provides better data, and there's an excellent argument at the License Appeal Tribunal that any functional assessment that takes place outside of the home doesn't truly represent someone's needs within their own community or within their own home. It also would provide the occupational therapist an opportunity to see the home and see what challenges might be faced, as opposed to a sterile or sterile clinical environment, which might not have the challenges associated with a person's home or a person's community. This could be particularly true if someone doesn't have access to public transit and has difficulty with making decisions. So the ability to make a novel decision while driving, for example, could impact their overall functioning. Now, and one of the challenges for plaintiffs' counsel is often trying to make sure that we focus on the big picture in these types of claims. And while oftentimes it can be more expensive to have a claim or an assessor travel to see our clients, it ultimately provides better data. And the data is what makes the application a strong one. And strategically, once you go to the LAT, there are reasons that make your data stronger, that make it look like you're actually assessing the plaintiff as opposed to trying to simply deny a benefit or deny a status. With respect to neuropsychologists and that cross-examination that I spoke of earlier, really having the opportunity to force them to rely on their own or on our own data is a massive advantage that we need to exploit at every opportunity. Other obligations that fall on the insurer, which we're sometimes seeing, is that oftentimes the insurer is trying to use the GOSE assessment to assess things that aren't relevant for the purposes of the GOSE. So, for example, we'll get a suggestion that an orthopedic assessment is necessary for the purposes of the GOSE. And in those cases, what we do is we push back and ask them for a medical basis for that specific assessment, because really there isn't one when it comes to function. An orthopedic surgeon isn't able to assess function as much as an occupational therapist, for example. So oftentimes we're finding we're pushing back, and insurers are ultimately relenting on some of these issues because they realize that the standard shotgun approach to simply completing as many assessments as possible doesn't apply under the GOSE, and it frankly won't work as an attempt to stack the deck against plaintiffs. These are some of the advantages that we're seeing right now. Unfortunately, they're all theoretical examples until we get a decision from the LAT on GOSE, though we're trying to set ourselves up for success by putting these factors in our favor as much as possible. We're hoping that in the coming months we'll get some clarity from the LAT on the GOSE, and we make sure that we keep up to date with these things. In order to really keep up to date, we've developed a service at our firm called the LAT Update. If you'd like, you can go to oatleyvigmond.com to sign up, and we take recent LAT decisions and new LAT decisions that are of significance to both lawyers and healthcare providers and circulate those decisions so that everyone is using the decisions and the newest information when proceeding with applications such as the GOSE. Thank you.
Thanks, Kevin. And Kevin, let me just follow up a bit on your presentation. I mean, what I do and what we really emphasize at our firm, and I'm sure you as well, is that with this new test, the GOSE, you must get your ducks in a row right away. The minute you meet with your client for the first time, and they're potentially are CAT or likely to be CAT, I mean, I take it that's the time that you start preparing for this important 6-month time frame, right, or 1-year time frame.
Yes, absolutely. So you start the monitoring process with respect to that as early as possible to see whether or not you ultimately believe that they might meet the GOSE test. And even if they don't ultimately meet the test, it's important to be prepared for those 6-month milestones because the sooner you get a jump on that assessment, the more difficult it is for the insurer to complete a fair assessment that actually measures disability or function.
Yeah.
And if I could add to that, if they don't meet it at the 6-month mark, doesn't mean that they won't meet it at the 12-month mark. So as they develop through and work through their injury, symptoms could develop that they could be at a lower moderate at 12 months.
Okay. And what I've experienced is it's so important to work with the full treatment team. The lawyer, the law clerks, and the full treatment team, especially in the early stage where there's often the OT has to wear 2 hats as a quasi case manager at the start before a case manager is involved, and we can't emphasize enough how important it is to get all your ducks in a row, so to speak, with respect to the team, to be super organized from the outset and work together towards these key dates of obviously discharge, very important time, then 6 months or perhaps 1 year. Okay, so now Lindsay from McLeish, Orlando. Lindsay will talk about how the ORA is helping clarify issues of attendant care and case management rates following LAT decisions. And I'll just introduce Lindsay briefly. Lindsay's a lawyer at McLeish, Orlando. She was appointed to the Brain Injury Association of Durham Region and is a member of the Law Society of Ontario and the Ontario Trial Lawyers Association. So, Lindsay, go ahead.
Thanks, Carr. So as we all know, the changes to the definition of CAT have had a profound impact on our industry, and we've learned a lot about some of them today. So what are we really seeing? First of all, we're seeing less people going catastrophically impaired. And the second thing we're also seeing is that it's taking much longer for people to go CAT, especially when you're looking at someone who may have a brain injury. And that's because the GCS thing is out of the picture, and we're going through the GOS-E, which takes at least 6 months to a year and onwards. So what are we seeing? We are seeing that a lot more clients are having to rely on protected accounts to get treatment. So what is a protected account? A protected account is an irrevocable agreement between the injured person and a treatment facility or an individual therapist where they agree that payment will be due upon settlement of their lawsuit or an accident benefit claim. Sometimes there's interest attached to that, and there's an agreement between usually the firm, the injured person, as well as the therapist. So that's what a protected account is. Where are we seeing these used? Well, there's really 2 ways that we're seeing these used. One is in the medical and rehabilitation side of things. The other is somewhat in the attendant care side of things, although the ORA is really helping us out. And hopefully that's a bit less. So for the med rehab, why is this happening? First of all, like I mentioned, a lot of the time there's only $65,000 of limits. People are not going at CAT as quickly who are severely impaired. So they are blowing through these med rehab limits before they're deemed catastrophically impaired. They still need the treatment, so they're relying on protected accounts to get that. The other side of it is the reality of the harder test for catastrophic impairment, where not as many people are going catastrophically impaired, yet they're still fairly impaired, requiring them to rely on these protected accounts. Then the other thing, previously until the ORA helped us out again with getting Fisco to address issues with a bulletin, was in case management for a brief period of time, case managers who were social workers or other providers were only being allowed to charge a case manager rate as opposed to their professional rate, which was leaving a discrepancy, which at times, if the client really liked that specific case manager, may fall to a protected account to make up that difference. So turning to the attendant care side of things, there was the decision of AH and Belair, which essentially said that an insurer only had to pay for care according to guideline hourly rates for professional services, which are below minimum wage. So this left a whole bunch of personal support worker companies just simply not being able to afford to charge out PSWs at that rate. And for someone that requires 24-hour care or something like that, where they really need the care, a lot of law firms were hoping that protected accounts could be used. So where are we now? So let's be a little bit positive and let's look to all the great things that have happened in light of some decisions which are a bit harmful to the injured parties. So in concert with the coalition, the Ontario Rehab Alliance was successful in getting a bulletin to help return the attendant care rates to the pre-AH and Belair status quo. So hopefully that means that protected accounts are less frequent for attendant care. And then the ORA and the coalition was successful in implementing the same sort of bulletin for this case manager situation. So if you're an OT that's providing case management services, you'll be allowed to charge your OT rate as opposed to the case management services rate. So that's, again, another small victory to hopefully reduce the amount of protected accounts that may be used at this time.
Lindsay, let me interrupt you for a second because the questions are streaming in
Oh,
here.
no.
Can you explain, just for our viewers, what the ORA is, what it stands for, and their role just in the process?
Sure. So the ORA is the Ontario Rehab Alliance, and for the knowledge that I have, they've done a great job specifically with these two decisions that made it really tough for healthcare practitioners to work with clients to provide the services they need when they're kind of constricted. So essentially, you have to become a member of the ORA, and then if you have some sort of issues where you're concerned about the way an insurer is taking a position on something, or there was a decision that negatively affected you, you can reach out to the ORA, and the ORA can help try to address this. So just so you can kind of understand the process a little bit, and this is from my understanding, if you're a member of the ORA, you can call to advise of a situation or a perceived issue. And then the ORA may send an email to all of the members, which is then circulated to see if this issue's become common with other healthcare practitioners. If it is, the ORA tries to gather further data to figure out what's really going on. And once they do, depending on the severity of the issue and if they think it's something that should be addressed, they may be able to address it with Fisco's policy division and potentially different ombudsmen at these insurance companies. And they also have worked with different coalitions to try and make their voices heard. So the key is to check out their website. There's tons of information on there. And then the other thing is that you do need to be a member to kind of access all aspects of that. But fortunately, the ORA has done a lot for all of us. So I encourage you to check out their website so you can get further information on that.
Okay, so basically, I take it's an organization that gives healthcare, those involved in the healthcare industry, a voice where, perhaps, if they just speak up on their own, perhaps it may not go as far, but as this alliance, they can work together and promote change.
Yeah, so that's my understanding. There is a way that you can raise a concern to Fisco directly. There is kind of a person that deals with concerns from both the insurer side as well as the treatment provider side. And I think I have that information here somewhere I can provide to you. So there's a lady named Yelena, and she's at Fisco. And if you have any concerns about insurer conduct, you can also reach out to her directly. So that would be separate and apart from the ORA. But what I think is really neat about the ORA is a lot of healthcare practitioners end up working together to try to promote change. And it's easier when an insurer or Fisco sees that it's just a systemic issue. It's not just a one-off kind of issue. So that's, in my mind, your advantage of reaching out to someone like the ORA if you perceive there to be an issue.
Okay.
Okay. Is there any other questions you want me to address now?
Yeah, I just got one from Tamara, who asked a question online here, and she said she's a social worker. And she wants to know how the fee guidelines or lack thereof can be disputed now that the insurers are significantly decreasing their rates. And I thought that kind of touched on the Belair case to some degree and the bulletin that followed. Do you have anything, Lindsay? Perhaps you could take that one as. You know the Belair case pretty well.
Yeah, so the Belair case is what deals with the attendant care rates, and the JA case is what dealt with a social worker providing case management services as a social worker. And there's a bulletin, Tamara, I'm not sure, you've probably seen it, but it's bulletin number A-03/18, and it's titled Revised Attendant Care Hourly Guideline and Clarification of Healthcare Providers Subject to the Professional Guideline. So the professional services guideline, it says specifically here, as specified in the PSG and in Bulletin 0204, unregulated providers and other regulated providers not listed in the PSG, example, social workers and physicians, are not covered by the PSG. The amount payable to service providers are not covered by the PSG is to be determined by the parties involved. And then it goes on to say, expenses for regulated and unregulated providers identified in the PSG are payable to according to their professional designation and not by the services they provide. For example, case management services provided by an occupational therapist are payable at the occupational therapist rate and not the case manager rate. So that's what that bulletin deals with, Tamara. I'm not sure if that's specifically your question. If you do have follow-up to that, I'm happy to send you a quick email and you can kind of tell me if there was discrepancy between your question and the answer I provided.
I could maybe add something to that. In the case of a social worker and the hourly rate, and some insurers are just mandating an arbitrary $100 an hour for social work for a non-catastrophic claim and maybe $120 for catastrophic. Given what you've just said about the professional services guideline, my understanding is it's not the sole decision of the insurance company as to the hourly rate. It's an agreement. There has to be a dialogue, and that involves looking at the social worker's clinical experience and education. So you might want to have that discussion with the adjuster if you've been put in that situation.
One thing that we're doing, Lindsay, when you spoke of protecting accounts, that's something that sometimes healthcare workers can only protect so many accounts, right? They have a business to run as well, and they need to get paid. One thing we focus on is I look more towards advance payments in tort.
Yep.
That's something where, I've changed my practice a great deal since these AB changes to seek advance payments. Generally, you need a pretty good case on liability and certainly clear damages to even entertain the possibility of an advance payment. But is that something that you or your firm are really looking at in response to these changes?
Yeah, I think definitely that helps, especially in this GOS-E situation where you may have a client that has a severe brain injury and it's kind of clear in tort that they'll receive fairly good compensation, but they literally just need the money to be able to survive. So writing to the tort lawyer, hopefully there's someone that's been on the file already, or simply the tort adjuster and trying to seek an advance, it can be helpful. There's no guarantee you'll get it, but at least trying definitely helps out because it, like you said, it's really hard for healthcare practitioners just to have these endless protected accounts for people. So for sure.
Okay, great. A question came in from Elaine Lowe, and Bani, this might be a good one for you. Who is qualified to do the GOS-E? And Elaine asks, is it only an OT?
Well, here's where I can toot my own horn and say OTs are actually the fundamental training that we receive in OT program is looking at the three aspects of person's daily functioning, which is self-care, productivity, and leisure. And then we further look at each of these domains under the physical, cognitive, and emotional aspects of self-care, leisure, productivity. So I feel like the structured interview form really speaks to our training, but not to say that other professions cannot administer it. In fact, it was developed by a psychologist and initially administered by a nurse. So I think what the key to doing a GOS-E assessment and completing the structured interview form is really having a solid understanding of your ABI symptoms, what the physical symptoms are, what the cognitive symptoms are, what the emotional symptoms are, really knowing the client, getting to know their family, their collateral sources, and seeing how the ABI has impacted the 5 domains. So if you feel like you have a good handle on it and could put down a solid narrative on each of the domains in terms of where they stand, whether they're impaired or not, you need to be able to justify it in a functional way rather than just based on paper-based testing. So it's not a subjective interview where you're just asking them, you know, if there was a fire in your house, what would you do? You actually have to go ahead and make them do these things and put them in scenarios where they have to respond to those stressors to get a true picture of it. And I think if you feel capable of doing that, like I said, it's been developed by a psychologist, administered by a nurse. I know physios do it, and OTs do it, and nurses do it. So it's not limited just to the OT profession. It is actually limited to the depth of your knowledge about the ABI injury and its impact.
Thank you, Bani. Kevin and Lindsay, I'll ask you both this question. The changes from Fisco to the LAT, I mean, from a lawyer's perspective, and from an access to justice issue, which I touched on earlier, the fact that you can't really get the costs in the LAT, and if you do meet their very difficult testing costs, you know, that it's vexatious or unreasonable. It's always very low. I mean, the cost decisions at the LAT, it's you know, $700 I read, or $500. So. And they consider that to be a significant cost award. So it's troubling if you have a client or, you know, who you know, you have an issue with the LAT, and you know, even if you're going to win, you're not going to get paid, and their legal bill will not be paid, or a portion of it for fighting for them. So have you changed your practice in any way?
Yeah, so there's been a big change between like the LAT and Fisco, and I think for us it's because the LAT moves very quickly, so there's a lot of significant things that used to take years before we get to a Fisco arbitration, and I may already have tort reports that I can use at that arbitration, but sometimes we're going to be getting to these hearings well in advance of tort catching up, we'll say. So what I've been finding is I work very closely with the healthcare practitioner team, similar to what you both have been describing in terms of making sure you have your team set in place right away, making sure the team knows the collateral people that they should be speaking to, reminding the healthcare practitioners the importance of specific examples, because in the back of my head, I constantly have to be thinking, I'm going to be at an arbitration. I probably won't have as many reports as I'd like to have because of the cost issue, like Carr mentioned. So I'm going to need to rely on some amazing clinical notes and records from my treating healthcare team. So as lawyers, we love to have specific examples. We love to see specific examples in our reports. So if you're an OT that's treating, or you're a rehab support worker, or maybe even a psychiatrist or psychologist, any of those people, if you have specific examples which may play into Bani's GOSE assessment, this is really going to help. And then I can pull that information and I can present it to an insurer at a case conference, which is way more holistic now than a Fisco mediation used to be. And hopefully I can, you know, sway their opinion at that point. But if not, I've got my ducks in a row, like we all discussed, for an arbitration with specific examples, so that may affect the adjudicator. So I really work closely with the trading team. Not to say we didn't before, but it's just of that much more importance now. Sometimes I try to get kind of these mini reports from key players. They're quite short. They try to address specific aspects of the file where I think I may need more strength for, you know, a GOSE assessment. Yeah, I think that's kind of how it's really changed.
I would like to add too, so you're talking about the mini reports. So treating OTs tend to send in progress reports quite often. And so keeping the structured interview form in mind when they write these reports, addressing each of the 5 domains when they write that report in terms of how the client is doing right from the get-go, I think would help in documenting it and giving specific examples, because sometimes, 6 months down the lane, you've forgotten that this is what happened to the client, and it just goes to the wayside. But when you actually document it in the progress reports, then that's helpful for you.
Yeah, exactly. And I think also, I think if you're a person that is regularly seeing the injured individual as well as their family, their friends, if you're taking specific notes and asking, cueing the collateral sources, if you will, on the specific types of areas that may be applicable to the GOSE, it really helps you out, because inevitably families are already overwhelmed trying to take care of an injured individual. So the likelihood of them remembering all these specific examples at a CAT assessment 6 months later, when they've just been in a rehab hospital, they've just been in a major trauma unit, is fairly low. So try to help them out. It's hugely helpful to us as lawyers if we have that information. And I think GOSE assessors too. So I think that's kind of the major change for me, Carr. I'm not sure, Kevin, if yours is different experience.
I find that there's more strategy involved at when to pursue something to the lap, as opposed to with fiscal mediations, we would often be bringing them as soon as the denial came in, oftentimes adding those issues at a failed mediation to a lawsuit. In our case now, we're typically trying to coordinate our denials on the AB side with our tort action, so that we have tort reports and we have items that we're able to pursue at the same time, and that we can have similar evidence on. It allows us to use these reports in a way that is advantageous and cost effective. So that's something that we're really trying to do. The other issue, and it goes more to dealing with the evidence itself at a tribunal or a hearing, is that we don't always insist on every witness attending in person anymore, because oftentimes it might not be cost effective, and it might also not be a cost that's at all recoverable. So we're sort of thinking outside the box on how to best prove our point with available evidence, and also perhaps coming to agreements at the case conference about what types of evidence we need to call in these particular circumstances.
Thanks, Kevin. One thing as well, I'm getting quite a few questions with regards to protected accounts. Everyone needs to be aware, of course, that there's case law in tort saying that that when you're fighting something on the AB side and going through the LAT, you can recover those costs for doing that. So I know our audience is mostly healthcare workers, but of course the lawyers that are watching this as well, I'm sure are aware of those cases. But moving forward, Kevin and Colleen, I'll just ask you a question that came in. Is an insurer obligated to pay for a second CAT assessment if an earlier application has already failed? Kevin or Colleen, would you like to take that one?
I believe that they are obligated. Medical status can change, and as long as it's reasonable, you've got rationale for it. I don't know, Kevin, what do you think?
I agree. I mean, as Bani mentioned, the GOS-E testing between the 6 and the 12-month mark can change so substantially that you might ultimately have someone who might not meet the 6-month test, or an insurer doesn't feel meets the 6-month test, who ultimately meets the 12-month test. So in my view, as long as it's a reasonable application, and it makes sense that the insurer would have to pay for both of those assessments.
Okay, and Lindsay, you touched on this a little bit earlier, but are insurers obligated to pay out protected accounts once a person is declared CAT?
Oh, okay. So I think in answering that question, what we have to remember is that you need to keep submitting ongoing treatment plans. You can't just build up this huge protected account on your AB side of things and not have any treatment plans regarding those accounts. So there's actually a case that dealt with this, and it's PK and CUMIS, CUMIS General Insurance Company, and the adjudicator said, essentially that this applicant incurred over $20,000 of expenses out of her own pocket. However, the applicant must submit an OCF 18 before she incurs an expense for a medical and rehabilitation benefit. It's required by law. So they had no ability to pass that requirement, regardless of the party's intentions of it being submitted. So considering that, it's a good idea to have treatment plans on claims, even if your coverage is exhausted. So in this case, the person was in the MIG. They eventually got out of the MIG, but it wasn't just an automatic, okay, here is your $20,000. So it's kind of a reminder, I guess, from your legal side, we may be asking you to submit ongoing treatment plans, and that's the reason why. Colleen, I don't know if you guys...
Yeah, I think that whenever we're looking at a protected account, we want to have the treatment plan submitted, and if it's denied, we can go back once there's a determination of catastrophic impairment.
Yeah, so
Sure.
Oatley Vigmond did a great blog on this issue. So it's called Protecting Future Rights to Payment After Coverage Limits Have Been Exhausted. So if you're curious about that, they've really explained that issue well. So I'm sure you can find that on their website.
All right. A question came in from Kelly at Benchmark at IME. And Bani, this might be a good one for you. I'll just read it here. The GOS-E does not directly distinguish between disability due to brain injury and disability due to other bodily injuries. However, in the spirit of the SABS, the assessor should rate according only to the functional impact of the brain injury. How is the OT making that distinction in their assessment?
Okay. Yes, I do agree. It doesn't make that distinction. So when you're saying if the client is not able to leave their house, maybe they've, injured, they have an orthopedic injury in their lower extremities, is that the reason why they're not being able to exit the home in a timely manner? So again, it falls back into my narrative that I use when I grade the disability level. I really just focus on what are the physical, cognitive, and emotional symptoms related to the client's ABI. So I presented a chart earlier when I was speaking, and we will make that available online. So I follow that chart and look at, if the client is not independent inside the home or outside the home. I believe the chart is up now. You're looking at the physical aspect of the injury, the cognitive aspect of the brain injury, and the emotional, and commenting on that. I make my distinction based on these criteria, and I really just solely comment based on these symptoms. So whether they're not aware of doing so, whether they need cueing and prompting to do their daily tasks, or they are just not safe because of their impaired motor coordination because of the brain injury, their dizziness, their light or sound sensitivity. So those are the things that I look at which could be impacting the domains. That's how I make the distinction.
Okay, thanks for that, Bani. Kevin and Colleen, with regards to insurer exams, particularly with respect to those that are time sensitive, i.e. the 6-month mark or the 1 year, those key GOS-E dates that we've talked about, what can we do if the insurer is slow in responding to the application, or if the IE dates are scheduled for months after the application?
Well, I think that you have a discussion with the adjuster about maybe looking at alternate insurer examination providers who can provide earlier dates. I know that some physicians provide dates to various vendors, so an earlier assessment date may be able to be obtained that way. Maybe the client's going to have to travel more. I guess you have to just be creative in figuring out how you're going to get it done. And maybe you have the assessment part, the functional part of the assessment take place right away, and have the reports done later. It is a dilemma.
There are a few things about that are interesting. Really, the insurer will ultimately know that a GOS-E application is coming if you've put your documents in and had ongoing communication with the adjuster over time. So they actually have had time to prepare and set up their assessments. So, if they're waiting months down the line, they actually face an issue with the validity of their testing once they go to the LAT. So, we can take advantage of their disorganization or their failure to act by, letting them set up a 6-month GOS-E exam at 9 months, and we can challenge the validity of it later, and we can show our reasonableness in letting them know the application was coming and giving them the heads up, so that they have really no excuse once they get to a LAT hearing about why they have this invalid test out there, or invalid results.
Okay, and another question touches, I think, on what you both just discussed, and it's insurers will at times refuse to schedule an IE to determine CAT impairment until they have a long list of various medical records, and this can obviously contribute to delay in the completion of the insurance exam by many months. And is this reasonable?
I suppose the answer always is it depends.
Yeah, of course.
If you're not, as plaintiff's counsel, if you're not producing the records, then that could hinder their ability to do a fair assessment. So what we do is that we, from day one of the retainer, we are getting record requests out so that the insurer has the most up-to-date records possible, and it allows us later on to say, look, you've had all of these records. This isn't a case of us unreasonably withholding records. This is a case of you asking for things that are either irrelevant or not yet available. So, and then it turns back again to the validity of the assessment and delays associated with it. If we can demonstrate that the delays are on the insurer and not the claimant, it's really a great advantage.
Okay. Question just came in from Fiona, and Bani, this may be a good one for you. It's if a referral is made late, say if someone is late in the process in terms of the GOS-E, and a GOS-E is done after the 6-month mark, maybe at the 8-month mark, and the person is meeting the CAT definition at that time, is that a valid application?
It absolutely is. So even at an 8-month mark, you could still be completing a 6-month review. Okay. As long as you have appropriate documents and collateral information. And even at the 14-month mark, you could still do a 12-month review. So timing is variable, and I think Kevin would agree to that. You just mentioned that.
Yes, certainly.
Yeah.
And Bani, for our audience, these key dates that everyone has mentioned, the 6-month or the 1 year, what is the difference between those assessments?
Okay, so when you do the 6-month assessment, you're looking at the first 2 domains, which are really important at that time. So this is 6 months post-injury. If the client meets severe disability, doesn't matter if it's upper or lower, in those 2 categories, then the client is considered catastrophic. You're looking at whether they're independent inside the home and independent outside the home. Again, you're looking at their ability to do self-care tasks without prompting and cueing. You're looking at their safety and awareness with respect to handling themselves throughout the day, if not the entire 24 hours. And then you're also looking at their ability to travel in the community as well as shop. So those are the heavier, that's a heavier focus in the 6-month assessment. And then when you go to the 12-month mark, they can be deemed CAT if they meet at least the lower moderate disability criteria. And that encompasses then your 1 year post-injury, you're also looking at the impact of injury on their ability to work, their social and leisure activities, as well as their family and friendship. So if any of those have been compromised because of the injury, then they still have a chance to meet CAT, even at a lower moderate disability level. So that's the real difference.
Okay. And while you're on the hot seat, so to speak here, what's the difference between the GOS and the GOS-E?
So the GOS and the GOS-E, in terms of the structured interview form, they have the same domains. So when you're looking at the GOS and the GOS-E, they have the independence inside the home, outside the home, work, social, leisure, and family and friendships. The GOS was actually used before the June 2016 changes, where it was used at the 6-month mark. And initially, the client's GCS score was calculated, and then if at 6 months mark they met the severe disability, then they were deemed CAT. If they didn't, then that was it. So now there's a second chance for a client to meet CAT with a GOS extended form, which actually it splits up the grading criteria into, so first there was only dead vegetative state, severe disability, moderate disability, and good recovery. So it was only a 5-point grading scale. Now it's become an 8-point grading scale with the GOS-E. So you can be upper or lower disability, both in the severe and moderate. And that sort of gives a client more leeway to still be disabled. So that's the difference. So before, GOS was being used before June 2016, and now as per the SABS criteria, we are using the GOS-E. So it really depends on the date of the accident.
Okay, and could you do GOSE assessments as part of a treatment team?
Absolutely. I think Lindsay just mentioned it. If you actually make it a part of your progress reports, you could very well show the client's progress or deterioration either way with respect to the impact of an ABI. So if you're a treating OT, if you're thinking in terms of the structured form, you can build up your assessment within your treatment sessions where, if you're doing meal prep with them, if you're doing a community outing with them, even if they're doing it with the RSW, you're looking at what kind of prompting cueing, what kind of errors do they make, and what kind of assistance that they need. And if you document that accurately, that can all form a part of your assessment that you do later.
Okay. Lindsay, I'd like to know just about your experience with respect to at the LAD, the case conferences, which, I mean, prior to everything moving to the LAD, it used to be Fisk OC mediations, and at Fisk OC mediations, I mean, both parties knew that if they were unsuccessful at Fisk OC, that there were cost consequences flowing from it, and that's obviously changed now. So do you notice a difference in terms of the case conferences and the former the Fisk OC mediations?
Yeah, sure. Before can we jump into that? I just wanted to clarify something I said earlier about the protected accounts. It's not just that you submit treatment plans when you've exhausted your limits and then they'll back pay you for everything. Those treatment plans would still need to be considered reasonable and necessary. So I just wanted to make sure that was absolutely clear, which I think everyone probably knows, but just to make sure. So the difference between Fisk OC mediations and case conferences for us is huge. A lot of the times Fisk OC mediations, like Kevin mentioned, you would get them in right away and you'd proceed immediately. Timing is everything in the LAT because you have to make sure you have your ducks in a row for that case conference, because you're going to be at an arbitration within 2 months of your case conference. So at your case conference, you're essentially going to have to be ready for your arbitration, which is a little bit different than the way Fisk OC mediations used to work. And then, of course, the arbitration dates were so pushed out. So a case conference is really almost like a pre-trial in tort. So I'm going to have to know my experts. I'm going to have to know what all my experts are going to say. A lot of the times that will involve me calling a healthcare practitioner before my case conference because I need to know the strength of my case before I'm actually at that proceeding. So yeah, it's changed a lot. Sometimes you can have very useful settlement discussions. Sometimes you can't. The adjudicators are pretty good at procedural issues in terms of what type of hearing it is. A difference, again, is that there are written hearings, so you need to be able to agree on when you can get affidavit evidence if there's, if it's a hearing in writing, which is another difference for healthcare practitioners to contend with. You have to know if it's going to be a blended hearing, if you're going to have cross-examinations on affidavits. So all of these things didn't really ever come up at a Fisk OC mediation. So again, it's the importance of open communication with the healthcare team as well as the legal team at a much earlier stage of the litigation process than we're previously used to compared to Fisk OC.
Sorry, Carr, if I could just jump in as well. There's also the other side of the lack of cost consequences can allow us to strategically push for various things in the case conference. So in particular, if I have a case involving a treatment plan that isn't over a significant amount of money, my preference at the case conference is always to push for an in-person hearing, because that simply increases the costs of the insurer to actually have and attend the hearing. So particularly if it's a client that's in a rural area, for example, and the hearing has to take place in the community in which they live, it ultimately results in a significant cost consequence to the insurer if they have to attend an in-person hearing. So oftentimes we're getting these decisions at a preliminary stage from the case conference hearing officer saying, yes, it will be an in-person hearing, which allows for settlement discussions on those specific issues because the insurer ultimately doesn't want to have to proceed to an in-person hearing outside of the GTA, for example, given the inavailability of costs.
A lot of questions are coming in from the speech language pathologists. Thank you. I'm just going to ask, just generally, Bani, can you discuss the importance of an SLP, their role early in the process where
Right.
you're gearing towards that GOS-E at the 6-month point?
So I've read the question that Jennifer sent in. She's asking if the validity of their records for clients' ability to communicate. How important is that, especially for people who are not working before the accident, people who are students or have vocational goals, so non-competitive work such as volunteer activities or committees that they sit on. So yes, the SLP documentation would be really helpful. That would form a part of the medical file review. That would be very important in making a strong application. So if we get report cards, if we get progress reports from school or colleges or feedback from their supervisors just to see how their ability to handle and communicate to others has changed, that really makes a big impact on us to comment on their social and leisure activities. Maybe they're even under their work category if they're a student, their ability to retain information and communicate, as well as the final family and friendships, because that would also impact the final 3 categories. So I think it's a very important role.
Bani, another question came in. It's just with regards to clients who may get nervous when they're being tested, which is common, and it touches on overreaching. What can we do? What can the healthcare community do to protect our clients from overreaching in the multidisciplinary assessments?
I think debriefing them before and after the assessment is a really important part. So when you go in, if you truly explain the purpose of your assessment, that sort of helps to calm their nerves. It doesn't mean that they'll always be calm and that it works on all clients. But to prevent that from happening, you really have to define what it is you're looking for and explain that in an objective manner. So you're not skewing the assessment in either way. You're just basically looking at their ability to do tasks that they were doing before the accident at the present time. That's all the instructions should include, but at the same time, they have to do it at their current ability. So if you debrief them and explain the premise of your assessment right off the bat, then I think that sort of sets the tone and they become less nervous. I found that at least in my assessments.
It seems we have a very engaged audience here, and there are a lot of questions here, and I don't know that we'll get to all of them. So as I said at the beginning, and if anyone was tuning in a bit later, we will answer each and every one of the questions asked here. So if we do not get to yours today, we certainly will very soon. Bani, a question just came in from Heather, and it's a good one. She asks, I understand that the GOS-E requires the assessor to answer the questions based on the client's function in the past week. How critical is that point with regards to the past week with respect to the validity of the assessment?
You're actually looking at their patterns that have developed. So you're not just looking at the last week, you will be looking at since the injury. And while you're testing them at a specific point in time and you're looking at their functional ability, you're also drawing from in the past what has happened. So I think it really depends on your clinical opinion and judgment there. So I could say, last week he burned himself because he forgot to turn the stove off, but today in my assessment he turned it off just fine. So do I say he's independent inside the home and safe, whereas he's had 4 other instances before of not being safe? I would draw on the past experiences of the client as well as the current abilities that I observe, and then use my clinical opinion in my narrative for that domain to say, this is the reason why today he did this. This is, I have reason to believe that he may not be safe. So you're always erring on the side of caution.
Okay, and Bani, another question for you. I hate to keep peppering you here, but what are the key differences between the upper and lower severe disability as relevant at 6 months for the GOS-E, and the lower moderate disability as only relevant at the 1 year and after?
So it goes back to something I've mentioned before. When you look at the upper or the lower severe disability, it looks at, so the lower severe disability looks at whether the client is able to stay at home or alone or not, unsupervised for 24 hours. And if they're not, then right then and there, they're categorized as lower severe disability. But if they can stay for at least a part of the day, if their spouse is going to work or their kids are going to school, and for a good chunk of the day they're by themselves, they're able to, their family sets them up and leaves them with meals and medications, and they're sitting and they check in on them on the phone, but they're okay to be on their own. And then they come back, but they do need supervision through the remaining hours of the day, then that splits. So the upper and lower really just splits the 24-hour and 8-hour care that we're looking at in the severe disability form. And the lower moderate is looking at whether they're unable to work or, need severe accommodation at work. So that defines the lower moderate.
Okay, thanks, Bani. Kevin, a question for you, and I'll ask just how you explain the LAT to your clients, and this will be helpful with the healthcare community as well, because I'm sure they're nervous about the process. They don't really know how it works, and I mean the lawyers on it, the LAT's in the infancy, so we're kind of growing with it. We're still waiting for the first decision to assess GOS-E. So when you're just explaining this to your clients, this new LAT process, what do you tell them?
Well, I tell them, what the nature of the hearing process is and what their involvement will be from very early on, and what our goals for each hearing will be. And I gauge their how they feel and their comfort with the idea of whether or not they need to give testimony in person, or whether it'd be best to give that evidence by way of an affidavit. So I'm often gauging how they react to my explanation of the LAT as an administrative tribunal, and that it in some ways can be less formal than a court. So some ways you're able to put them at ease in suggesting to them that it's less formal than perhaps a trial on the tort side, but at the same time allows them to have issues heard in a relatively quick manner. So it's a combination of letting them know the advantages and the drawbacks potentially of the licensed appeal tribunal.
Okay, thanks, Tim. Colleen, your experience with the LAT so far, this big move from Fisk OC to the LAT, how have you noticed the change so far, particularly with clients who are close to being catastrophic and aren't at that 6-month mark yet? New files where you're just looking into things. How have you changed things to deal with the LAT?
Definitely more proactive and looking at getting a good solid team in place, really aligning ourselves with assessors and occupational therapists who understand the assessment process and getting the collateral evidence that helps with the application. Looking at getting the involvement of rehab support workers. It's fast. You've got to be on your game right as soon as you get the file in, and you're thinking about moving toward an application. It's so much faster.
Lindsay, for you as well, like the same question. I take it's probably a very similar answer. I completely agree with Colleen that it's all about timing, getting organized at the start. And once you're very organized at the start, the team kind of moves on the same path, and it makes things fairly straightforward. Do you have anything to add with respect to from Colleen's answer?
Yeah, I totally agree with what Colleen said. I think as a treatment provider, if you're dealing with someone that has a brain injury, where the GOS-E may apply, to really try to familiarize yourself with the GOS-E test so that you know what you're looking for. There are some fantastic providers that we've worked with that have really gone the distance to try to understand these tests so that they know what should be reflected in their clinical notes and records to be of assistance to our CAT assessors. We also try to work with the family as best we can. We try to bring it down to a level where they understand, so that if they may see a specific example of something that is just completely off, that fits nicely into a GOS-E assessment, then we try to get them to write it down so that they remember, so that when they are providing that collateral information, they're able to remember these specific examples, so they're not completely overwhelmed. So we really try at an early stage to do our best to work with the team, work with the family, work with the collateral people involved to set something up nicely for the GOS-E. It is challenging. We're all working together here, and I think that's kind of the biggest theme that's come from it.
Okay, thanks, Lindsay. Lindsay, have you heard, or do you have any idea when we can expect to start seeing decisions from the LAT that deal with the new criteria?
I'd imagine soon, because I just for my own files, I know I've had files that have gone through our 6 months with Bani, actually, which is great. And just from a lawyer's perspective, what we did to get it right at the 6 months was we called ahead to Bani's center, I guess you'd call it, Omega, and said, look, the 6-month mark is this. I know that we're only 3 months out, but we need to have our client in there. So we were trying proactive to make sure they were in right on time. We are still waiting for IE dates, so this is well past the 6-month mark. So I imagine a lot of people are in my shoes too. I haven't personally gone through the LAT for a GOS-E hearing yet, but we've definitely had some GOS-E assessments completed.
And Kevin, the same question for you, just with respect to when do you think we can expect to see these LAT decisions that address the new CAT criteria?
Certainly, I think it'll happen in the coming months. I anticipate by the end of this year, we'll have received several decisions on these issues for the reasons that Lindsay outlined. Is that we've got these 6-month GOS-E assessments that are going through. I think there was a feeling out period initially when the changes happened. So I think now we're really looking at these 6-month and 12-month assessments that are being disputed by the insurer, which will ultimately end up before the LAT. There has been a significant number of cases, perhaps more than the License Appeal Tribunal was expecting. So there has been some procedural delays in getting matters heard and getting decisions back. So ultimately, though, I think this year will be a big year for the GOS-E and the License Appeal Tribunal.
Thanks, Kevin. Got a good question from Harriet at Neuro Rehab. And it's just with regards to the imaging, of course, that we need. I mean, we've kind of skipped over the imaging because we just assume that it's there, right?
Yes.
But we've all been talking about the step after you have the imaging, assuming it's there. But Bani, I'll ask you about that, just with respect to, what do you need in the imaging? What does it have to show?
I think just looking at visible damage is the first step to us creating the application in terms of if there is proof that there has been a significant head injury. I have seen cases where concussions don't show up on scanning, and these clients have, if I went through the GOS-E form with them, they would be severely disabled, but they're not eligible because there is no proper imaging. So of course, yes, you need valid imaging before we start the application for the GOS-E.
Okay, and Bani, I just got 3 questions in a row here.
Okay.
Everyone's peppering you here, I'll call it. And you touched on it earlier, but perhaps some people are joining us a little bit late. If using, it's a question from Nina. If using prior data, which is largely subjective and subject to inaccuracies based on elapsed timeframes, how valid is your rating when the GOS-E specifically states that in the past week?
Yeah. So you are going to rely on the subjective information chiefly in the last week, and you will find that people who are severely disabled, you don't have to go too far to look at instances or specific examples of things that could indicate their level of disability. So for the large part, I do find that within the last week, there is enough evidence to collect, which makes my assessment valid. I don't have to really go back to 2 or 3 months, especially when the client is severely disabled.
Okay. Colleen, a question just came in from Renata. Is neuropsychological appropriate to address GOS-E at both 6 months and the 12-month mark?
Yeah, I think, it can be appropriate. I certainly think you want to have a medical practitioner reviewing the imaging, and you've got your OT assessment, and I think it's good to have a neuropsychological opinion as well on the GOS-E. I don't know, what do you think, Bani?
Yeah, I do think a neuropsych assessment really adds value. Yeah, so if they look at, so typically we do the neuropsychs after the OT assessment, so they have the functional data to assess and to review what we've collected, and then they combine that with the imaging results and see what they can make of it.
And touching on the neuropsych exam, I just got a question from Neha. There has been some speculation related to the use of a neuropsych exam to generate a head injury diagnosis. If there were no positive findings in the imaging, I assume Neha is relating that to the GOS-E. What are your thoughts on that?
So typically we don't do a GOS-E assessment if there are no hard imaging of evidence of a head injury. So that's why we put a stop to it.
We're just wrapping up here. I'd just like to thank everyone for joining us. There have been a ton of questions here, especially in the last half hour. As I'm sure some people may have joined us late. As I said at the beginning, we will answer each and every question here by email. We have the email when it's typed in with every question. And importantly, I'd just like to remind everyone that the PIA Back to School Conference is on Thursday, September 20th at the Ritz-Carlton. Go to the PIA Law website because the early bird registration is now open and available until July 31st. I'd like to thank our panel today. I think we've had a pretty strong discussion just about this GOS-E. It's still in its infancy. We were talking before we started today about how we all hope that the first decision to address GOS-E is done where there's a good treatment team in place, there's good counsel on it, and they're all working together to advocate for their client, because we worry that if the first one is one that wasn't properly brought forward, then we'll have to deal with that. So we're kind of waiting to see, and we expect it, in the next, probably within the next 6 months, I would say, if not sooner. But you never know. The decisions at the LADAR, they seem to average about 4 to 5 months from the time there's a hearing till the time you get your decision. So it could be longer, but we'll very much see. But I just want to thank you all for joining us. And you can, if you missed any of the presentation, it'll be available on our website. It'll be up in the next couple of days. And I'd like to wish you all a great day, and thanks for joining us.